all welcome to Williamsburg. My name is Peter Pelham, the jailer. Now, just so you know, today marks the year of our father, 1775, which means that America is still a British colony. So the aspects of the laws that you will be learning today will fall into British common law with local modifications. Now, here in the courthouse, there would be two courts that would meet here every month. That was the Hustings Court, which is of that for the city, and it consisted of a mayor, a recorder, and 6 aldermen. And then you had the James City Court, which was that of the county, and consisted of 12 members of the magistrates of the justices of the peace. Now, things such as owning a license to run a tavern or a land boundary dispute, and is anyone here a member of the Church of England? Oh. Well, then you 3 would most likely be heavily taxed. But not only that, if you do not at least attend church at least once a month, you very well could be called upon the court and be punished for it. Wow. A bit radical in my sense of thinking, but who am I to say otherwise? Now, misdemeanor crimes were adjudicated here as well as felonies, but usually those were taken care of at the capital where the royal governor would act as a chief magistrate. Now, granted, where you all sit is called the public part of the courthouse, where crowds of citizens all across the colonies would come across to see that the courts are working in a proper and honest fashion, but also for the entertainment aspect, which I have a funny suspicion you all have come for as well. Now, we did have 2 sides of the courts here. Where you all sit would be the crown side of the court, and you would be the defense. Where you, Sir Madam, would be the defendant, and you, sir, the defendant's lawyer. And over here on the defense side, on this front bench, you, Madam, would be where the Deputy King's Attorney would reside, and you, his client, plaintiff. Now, it was the deputy's job to prove the defendant was guilty of the charges being brought against him, but it was his lawyer's job to prove that he was innocent against all charges from the crown side of the court. Now, of course, both sides of these courts had to come up with some sort of evidence to prove their point. But you see, in our time, our most valuable source of evidence was eyewitnesses. They could help locate certain things that were not come across at the crime scenes. Now, they would be located right here on these second benches here, and they could use as many as they could to either fill the bench or to help prove their point. Now, the defendant and eyewitnesses would be later called to this bar, known as the Bar of the King's Justice. Now, they were only called to it, but never passed it, for only those who were courtroom officials could pass this bar. Now, this desk right here, this was where the clerk would reside, and he was trained in all ways of the laws, but also had a number of texts upon his desk to make a reference to any law or crime, if need be, in courtroom proceedings. Now, I'm sure you're all curious about the benches up yonder. Well, let's go with the one up top, shall we? That was where, obviously, where the justices would reside, except for the large chair that I know. That chair there was for the chief magistrate. Now, the one down would be for if we were having a jury trial, where it consisted of about 12 men over the age of 21 who owned about 50 to 25 acres of land, but that depended entirely on the size of the house on the property, of course. But also, these men had to have a very strong Protestant faith at the time as well. Now, how proceedings would start was with your sheriff, for he would always be the first to speak in the courtroom of all court officials. And where he would be? Well, he would be in this little box here, known as the sheriff's box. So, he would be put in his box like this. He'd have a cane that would use to rap upon the floor thusly as such. Say, "Oyez, oyez, oyez! Silence is commanded here in this court today, for His Majesty's justices are sitting upon crime and punishment. Anyone who has business here in the court today, a plaint to enter or a suit to prosecute, draw near to the clerk, give your attendance, and you shall be heard. God save the King!" Now, upon that, the public will respond back with "God save the King." So, as a test, everyone, let's hear it. God save the King!
God save the King!
That there was a hearty one, I shall say. Very good. Now, once the court has then been called to order, known that, what was your name, madam?
Mine?
Oh, sorry, this,
Dawn.
Dawn?
Yeah.
That's Miss Dawn did knowingly and evilly at the instigation of the devil steal a hog from, what is your name, Miss?
Julie.
Miss Julie. Now Miss Julie had filed a complaint against Miss Dawn, and the sheriff believing the complaint to be true, arrested Miss Dawn, and now the defendant is ready to stand trial. For you see, everyone, animal thievery was a very, very common crime in our time, particularly hogs. Now, upon hearing this, the chief magistrate will signal to the sheriff to bring forward the defendant to the bar, where they are asked if they understand the charges that are being brought against them, but also, how does Miss Dawn plead? For you see, if Miss Dawn here were to plead that she was guilty, then of course there is no trial, and then you just move on to levy on what the punishment be on said charges. But let us say Miss Dawn here were to plead that she were innocent, then of course there is a trial. But then the next question would be, would she rather be tried by counsel or upon country? You see, if you chose by counsel, so that is whenever you would leave up your decision on innocence or guilt to the justices here. For it only took a majority of the justices to come to a verdict. But if you chose upon country, that is whenever a jury of freeholders would be selected. But the difference being, for a jury trial, the prediction of a verdict had to be unanimous. So Ms. Dawn here would have a greater chance of not being convicted if by a jury trial. Well, let's say you chose one or the other, Ms. Dawn. Then we move on into the proceedings. But we have to always start with the Crown side of the court. So, the Deputy King's Attorney would call upon the first witness, where they'd be asked to stand and to walk on over to the bar, where they are met by a clerk who had a Holy Bible in hand. Where then they would place the right hand upon it, and the clerk would ask those famous words of, do you solemnly swear that the evidence that you give today as testimony be the truth, the whole truth, and nothing but the truth, so help you God? And upon clearing that notion, the witness's testimony is then heard. Now, friends, you can very well possibly imagine how the Deputy King's Attorney would ask these questions to the eyewitness. For let us say that this witness and the plaintiff are known very well, shall we? Let's say that the witness is a neighbor whose bedroom window overlooks the plaintiff's pig pen. For if that were the case, then it is quite possible that the witness could have seen the crime committed, but be able to identify who the culprit was. But let us not forget the defense side, shall we? The defense will have the chance to question this eyewitness as well. And they would go back and forth on questioning the Crown's witnesses until they had come to a halt on their witnesses. Then it was the defense's turn to call upon their witnesses, and then they would go through the same process as before. Now, once both sides of the courts have rested, then it is high time that we come to a prediction of a verdict. So let us go back to say that this was a jury trial then, shall we? Well, the jurors will be asked to stand and be walked out of the courtroom and into another room and go through a process that is known as sequestering. And during this time of sequestering, well, let's just say that the jurors are treated in a particular fashion, where they are given no heat, no light, no food and drink, and no trips to the necessaries. I was just about to ask that too, madam. But anyone would like to answer the possible answer of why they were treated in this fashion?
They wanted to get a verdict.
That is correct, madam. They wanted to render a quick verdict indeed. Or let us say that there was maybe one or two or even three jurors who believed Miss Dawn here was guilty, but the rest thought that she was innocent. Well, they would continuously be taken back and forth out of the courtroom until they came to a united decision on whether she was found innocent or guilty. But let us say that they did come to a unified decision, shall we? Well, they would be led back in order to sit except for the foreman. The foreman would have to read the verdict aloud. And Miss Dawn, if you were found innocent, then you were free to go and not be charged with any of the fines that came with the charges as well. However, if you were found guilty as charged, well, that is whenever punishment must be levied out. For you see, a first-time conviction of stealing an animal of any kind will lead you to receive 25 lashes upon your bare back at the whipping post. Also, you'll be made to pay 10 pounds plus 400 pounds of tobacco for each animal that was stolen. Now, a second conviction could lead you to 2 hours of standing out at the pillory and have damages done to your ears. But you would still be made to pay 400 pounds of tobacco for each animal that was stolen. Well, let's briefly come back over here to the Crown side if it ruled in their favor. Miss Julie, well, you and whoever was the informer of the good testimony would split the 10 pounds plus 400 pounds of tobacco evenly as due. Now back over here to the guilty party then, shall we? Now friends, let us say that the thief was someone who was black or mulatto or even native to this land, shall we? If they were found guilty, they would receive 39 lashes upon their bare back at the whipping post. But also, friends, let us say that the thief was someone who was a servant or a slave. There was a bit of a difference on how that was handled. For if it were a slave, the owner of said slave would have to pay 200 pounds of tobacco, whereas if it were a servant, then the master paid 400. However, the servant had to work 1 extra month for each 150 pounds of the tobacco that was paid for by the master. And now, friends, let us say a rather large group of thieves stole one animal, shall we? Well then, for each one of those thieves, they would have to pay the entire sum for that one animal. And then finally, if a thief or thieves wanted their case to be taken to the general courts, well, that can only be done if a bonded security of 20 pounds sterling was paid. And that was then that their case could be taken and then heard. Now, I'm sure you're all tired of hearing the going-ons here in this courtroom and ready to move on to corporal punishment outside there at the pillory then. So, if you would all please follow me, we shall proceed forward. Ah, perfect. I have my 2 volunteers then. Back. Very good. Just rest your neck there and your wrist. Very good, son. Oh, sorry. All right, so, origins of this device, known as the pillory, dates to the end of the ancient Roman times, but was widely popular during the Middle Ages. Now, as you can see, you would have your 2 victims here, standing upon these 2 box platforms. The top bar would be lifted. They would rest their wrist here in these smaller holes, and their neck, the big one. The top bar would come down and lock them into place, holding them steadfast. Now, I did mention earlier it was 2 hours at most that they were punished for this. But it depended on what the crime was. For if it were a heinous one, well, let's just say, depending upon the wisdom of the justices, it could very well be a bit more than 2 hours. Now, I did mention earlier on damages done to the ears. Now, how this was conducted, you would take the lobes, and then you would nail them into the top bar here. Yes. And upon the time of release, the bar would be lifted up, and it would rip right through the nails. There you go, son, you're free. Yep. Which was how the mutilation of the ears came about, but this was not just as a form of mutilation, but also as a form of identification for the citizens of the public. This would help know if they were about to meet with the criminal or not, but that leads us to our next form of identification, the brand. Now, this brand here would be a bit smaller in diameter, and I should get to that shortly, but as you can see, there's a letter upon it, a T, as we had brands for all types of crimes. There were 2 widely popular ones, the T and a P. I'm sure you all can guess what the T stood for. Yes, for thief. Now, can anyone guess what the P stood for? Right, who said it? Pirate. Aye, that is correct, for pirate or piracy. You see, we still had pirate raids upon the colonies near the coast. Now, again, this would be a bit smaller in diameter. It had to fit just above the right thumb on the right hand, like this. Whereas, can I have someone shake my hand for demonstration?
Go shake his hand.
Oh, nice. Well, son, you'd be able to tell right here of what crime I had committed and that I indeed am convicted. Indeed. Yes. Now, another way of branding was also on the palm of the right hand, right here. Now this was kind of useful for those who would enlist into the military. Particularly, you would have officers where they would come across some individuals who could not read or write. So they would have those individuals raise the right hand and recite an oath of allegiance. Whereas upon that, they would be able to tell that they were about to swear in criminals. Now, other forms of brands were here on the cheeks, and then on the forehead. And that was that of the brand. Now back to the pillory. For a crowd of the size of this one that I see before me, you would all have a part to play in this. For, you see, a citizen would have with them a bucket full of rotten fruit and vegetables, rotten animal innards, rotten eggs, soured milk, and some would let it further rot and degrade, so much so until it was ready, where they take handfuls of this disgusting, smelly business, and they would throw it at said convicted, where they'd be pelted in the face, in the hair, and in the hands. Now remember, everyone, they'd be made to stand out here for 2 or even more hours or so, and if it was on a hot day as it was today, they would be in a rotten smell indeed. Now, these citizens were also known to carry with them stones for crimes of heinous ones, of that, to hurl at and cause injury. But let's say that I wasn't around to watch over the criminals as well. And there were these same citizens who would run up and physically assault the assailants as well. And whether they were hit numerous times with rocks or with fists, could lead to their death here at the pillory. I believe that takes care of that in the pillory. Now onto the stock. So if you would like to come a little bit closer to the stockade. Yes, the stockade is right here. It's quite similar to that of the pillory, particularly in the times of how long you'd be made to be here. But different, for instead of sticking your wrist and locking them in, here you'd be sticking your feet and locking the ankles. You would still need to bound their wrists behind them, for they would have to sit upon this arched iron beam that you see before you. About half an hour into this punishment, they would start to feel an excruciating pain upon their posteriors. So much so, they would have no way to relieve the tensions upon their bottoms. Now granted, I have had visitors such as yourselves see if they could match the 30-minute mark. However, instead of 30 minutes, it's more like 3 seconds. Yes, it's quite funny at times to review, but that says that for the stockade. Now on to the whipping post here. Now the whipping post. You would bring your convicted right over here. Now whether they were short or tall, you would raise the bars, and then lock their arms into place here, or here. And you would have to remove the back of their shirt, where they would be ready to receive the lashes upon their bare back with this cat and nine tails. Now, as you can see, mine is leather nuts. But the origins of this device dates back to the ancient Romans. However, their version, as we would call it here, was quite barbaric. What I mean by that is that at the end of theirs, they would have long grass strands. At the ends of theirs would be bits of metal, nails, bits of glass, bone shards that would dig deep into the skin, ripping the flesh out, mutilating their victim. But we here in the colonies, we're not looking so much as to mutilate at the whipping post, but as a way to remind them not to do said crime again on a first conviction. For if they did it a second time, it could very well lead to something a bit far worse. Now granted, I did mention earlier on crimes of felonies, yes? But just so you know a little bit, if you have committed a crime twice, those first 2 times are misdemeanors. A third conviction of the same crime becomes a total felony. Now that's not to say that there are no crimes that are total felonies. For 2 that come to mind would be murder and treason. And those poor individuals who were convicted on crimes of felonies were taken to the nearest tree, as that over there, and they were strung up by the neck, and that was that. For you see, they were given 3 chances to know of what was their intent to the public of the colonies. Was it to victimize them, or was it to become better citizens? Well, if it was the first, then the public would not let suffer that one to live. Which is why I would hope everyone here in the colonies would do no harm and wrong to one another, but also, please follow the rules. That ends my pleasant presentation of crime and punishment here in the colonial period. Does anyone have any questions? Yes?
What was the age, like the minimum age that you would be?
Well, as far as I can tell, it's usually been months as far as so, but I'll have to get back into my logs to see any, but I haven't come across any young adult, any young ones of this sort. However, there is always a first. Have either of you done anything terrible? All right. Then. Anyone else? Well, again, I would like to thank you all for coming. Please enjoy the rest of your visit, and try to stay out of the sun as much as you can.
Thank you.